Start. A perusal of this impugned summoning order indicates that learned magistrate had noted in the impugned order the contents of complaint and evidences under section 200 and 202 CRPC, but had neither any discussion of evidence was made nor was it considered as to what overt act had allegedly been committed by accused. Stop. This contention of learned counsel for the applicants cannot be ruled out that learned counsel have noted the contents of complaint and statements without considering its probability or prima facie case and whether he had actually considered statements under section 202 CRPC or the documents of the original. Stop. At stage of summoning, the magistrate is not required to meticulously examine or evaluate the evidence. Stop. He is not required to record detailed reasons. Stop. A brief order which indicate the application of mind is all that is expected to him at the stage. Para. But in impugned order, there is nothing which may indicate that learned magistrate had even considered facts of the case in hand before passing the summoning order. Stop. Impugned order clearly lacks the reflection of application of judicial discretion or mind. Stop. Nothing is there which may show that learned magistrate before passing of the order under challenge had considered facts of the case and evidence or law. Stop. Therefore, it appears that in fact no judicial mind was applied before the passing of impugned order of summoning. Stop. Such order cannot be accepted as a proper legal judicial order passed after following due procedure of law. Para. Summoning of an accused in a criminal case is a serious matter. Stop. Criminal law cannot be set into motion as a matter of course. Stop. It is not that the complainant has to bring only two witnesses to support his allegations in the complaint to have the criminal law set into motion. Stop. The order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. Stop. He has to examine the nature of allegations made in the complaint and the evidence, both oral and documentary, in support thereof, and would that be sufficient for the complainant to succeed in bringing charge home to the accused. Stop. It is not that the magistrate is a silent spectator at the time of recording of preliminary evidence before summoning the accused. Stop. Magistrate had to carefully scrutinize the evidence brought on record and may even himself put questions to the complainant and his witnesses to elicit answers to find out the truthfulness of the allegations or otherwise, and then examine if any offense is prima facie committed by all or any of the accused. Para. We feel that whatever be the outcome of the pleas raised by the appellant on merit, the order disposing of the matter must indicate application of mind to the case and some reasons be assigned for negating or accepting such pleas. Stop. It is true that it may depend upon the nature of the matter which is being dealt with by the court and the nature of the jurisdiction being exercised as to in what manner the reasons may be recorded. Example, in an order of affirmance, detailed reasons or discussion may not be necessary, but some brief indication by the application of mind may be traceable to affirm an order would certainly be required. Stop. Mere ritual of repeating the words or language used in the provisions saying that no illegality, impropriety, or jurisdictional error is found in the judgment under challenge without even a whisper of the merits of the matter or nature of pleas raised does not meet the requirement of decision of a case judicially. Para. Section 203 of the Code empowers a magistrate to dismiss a complaint without even issuing a process stop. It uses the words after considering, and the magistrate is of opinion that there is no sufficient ground for proceeding stop. These words suggest that the magistrate has to apply his mind to a complaint at the initial stage itself and see whether a case is made out against the accused persons before issuing process to them on the basis of the complaint stop. For applying his mind and forming an opinion as to whether there is sufficient ground for proceeding, a complaint must take out a prima facie case to proceed stop. This, in other words, means that a complaint must contain material to enable the magistrate to make up his mind for issuing process stop. If this were not the requirement, consequences could be far reaching stop. If a magistrate had to issue process in every case, the burden of work before the magistrate as well as the harassment caused to the respondents to whom process is issued would be tremendous stop. Even section 204 of the code starts with the words if in the opinion of the magistrate taking cognizance of an offence there is sufficient ground for proceeding stop. The words sufficient ground for proceeding again suggest that ground should be made out in the complaint for proceeding against the respondent stop. It is settled law that at the time of issuing of the process of the magistrate is required to see only the allegations in the complaint, and where allegations in the complaint or the charge sheet do not constitute an offence against a person, the complaint is liable to be dismissed. Para. Prima facie, the evidence means the evidences and statements in the summoning case has to be seen against the accused which are sufficient to constitute the offence stop. The inquiry under section 202 CRPC is limited only to test the truth or the falsehood of allegations made in the complaint stop. It is thus to be seen whether the material placed by the complainant prima facie makes out case for summoning the accused or not. Para. In the present case, the magistrate has not conducted any inquiry so as to satisfy himself that the allegation in the complaint constitute an offence stop. He has to further record his finding that statements recorded by him are sufficient to proceed. The ground for proceeding against the applicant is provided under section 204 CRPC stop. The magistrate has not applied his mind and summons have been issued stop. It is needless to say that summoning in criminal case is a serious matter affecting the dignity, self-respect and image in the society stop. The criminal proceedings cannot be allowed for harassment. Para. I have gone through the judgments and perused the record stop. It is abundantly clear that learned magistrate has not applied his judicial mind stop. He has simply said that he is satisfied on the basis of the statement recorded under sections 200, 202 CRPC, and therefore he summoned the accused. The court has to record reasons while summoning the accused in complaint case stop. The court cannot pass cryptic order without discussing the evidences and other circumstances stop. I am setting aside the order dated 2/7/2008 and remanding the matter to the concerned court for passing a fresh order stop. It is open for London Council for the applicant to raise all the pleas available to him stop. Over.